Hello, everyone, and welcome to this special presentation, what every real estate agent in Hawaii should know about the preliminary title report. And we're going to talk about some of the most common red flags, some of the issues that come up, and what you can do to solve them. And a great big thanks to this guy right here, Peter Paffrath from Title Guaranty Account Manager, for setting this up today. Peter, good to see you. How you doing today?
Great. Thank you, Patrick. Always a pleasure. So I have, as Patrick mentioned, I'm Pete Paffrath, account manager. I can be used as your first point of contact with TG. I'm a great facilitator. Anything that you think you might need, my advice is to start with me. I can help you with marketing, pulling a prelim, or getting you in touch with the right person within TG. Today we have Andrew Fortini on the call. Andrew is a senior title rep with TG. A lot of times he's the man behind the scenes. A lot of times you'll see his name right on that prelim, but he'll be available today to answer any of those tough questions that you might have. Thank you very much. My information and Andrew's will come up in a slide, but I'm going to pass it back to you, Patrick. Thanks for the opportunity.
Yeah, thanks, Peter. Thanks, Andrew. And we'll bring you back on a little bit later for the Q&A. We're going to move right on to our presentation. A familiar face to many of you, Jeremy Trueblood is a 20-year escrow veteran over at Title Guaranty. He's a vice president. He's also manager of the commercial division and one of the top residential escrow officers at Title Guaranty. And on a personal note, he's one heck of a good golfer. My go-to guy for all questions escrow. Jeremy, thank you very much for taking time today, and please take it away. Pull your presentation up.
Yeah, thank you, Patrick. Again, thanks for the opportunity today to meet with you and give a little bit of a knowledge about what the title report is, and then hopefully by the end of this today, you can leave understanding a prelim, but more importantly, knowing what to look for and what kind of questions to ask once you get a title report in your hands. So today, it's all about the preliminary title report. As mentioned earlier, I'm in the escrow side, so we're actually ordering the report, but the person who's generating the report and our title person is Andrew, and he'll be on later after I give the presentation to just answer some of those questions that you may have.
And Jeremy, let me just, I'll just tell everybody who's on the call today, we are going to have a few minutes for Q&A at the end of the presentation. So please drop those in down below in the Q&A section below. Okay, take it away.
Yeah, and I'm going to get my clock up here too, so I'm on track with
time.
I'll
keep an eye on you. You'll be good.
Okay. So here's the screen if you want to take a screenshot. Otherwise, I believe this presentation will be recorded, so you can always refer back to this with contact information for myself, Peter, and or Andrew. So today we're kind of broke down the presentation into three sections. The first part that we'll go over is basically what is the report, why is it important, why do you as an agent need to know about it, and how you can best serve your clients by understanding the title report. The second thing we'll do is we'll kind of dive into the meat of the report. And the biggest section of the title report is Schedule B. That's where we're going to find the encumbrances. And that's the part of the report you actually really want to kind of pay close attention to. It's going to be the areas where you might see some red flags, some things that might pique your curiosity. You want to delve into it a little bit more, find out what some of those documents are. So we'll talk about some of the more current things or things that you'll see within that report. And then the last thing we'll talk about is we'll talk about recording systems. So in Hawaii, we actually have two different types of recording systems. We'll show how the title report plays into that, and then what that actually means for you and your client when it comes time to closing an escrow and perhaps taking title, or the need to do a petition. If any of you guys ever had to do a petition before, it's a little bit intricate, and so we'll kind of talk you through some of that process. Let me move this over here. There we go. Okay, so a title report is basically a report that's generated by the title company when an escrow account is opened. Oftentimes you'll hear it referred to as a prelim, so that's short for preliminary title report. So when I refer to prelim, that's what I'm talking about here. But basically a prelim is a summary of the state of the real property in question. So it's going to show who's on title. It's going to show what the property in question is, the legal description of that, any type of encumbrance on that. So think of it as like a snapshot in time as of the date of the report of the current state of that particular property in question. Escrow gets involved by ordering the report because the Hawaii Association of Realtors purchase contract actually tells us to order that. So you may be familiar with section G1 of the purchase contract. It makes reference to a title report, and it says that the escrow company, by opening escrow, is already kind of instructed via the purchase contract to order a preliminary title report on the property and then deliver it to the buyers, sellers, and the brokers. So that's something that you don't have to do independently, because when a contract is delivered to escrow, we'll essentially have that open for you. Now, I would like to point out that title reports can actually be ordered at any time. And it's wise, if you're a listing agent, it's wise to reach out to your favorite escrow officer or your sales contact like Peter to ask for a complimentary title report. So we do offer complimentary title reports for brokers for your listings. So hoping to share with you the information that we have on the property in hopes that you bring the purchase contract to us. Ordering it early does a couple of different things. So to me, it's the biggest thing that you can do. One, it's going to make you look good if you go into a listing presentation to your seller. You can go in there knowing everything about the property already. You can already see what mortgages or second mortgages they may have on the property or any type of liens. If there's some title issues where, husband and wife are on title, but the wife passed away and you're just dealing with the husband, you can already come pre-prepared to that meeting, with some possible solutions about how to clean things up. Because kind of the last thing that you want to happen is open escrow, then you get the title report, and that could take a week into the escrow process. And then you find yourself, oh no, we have some title issues that we have to address. And God forbid it's a land court property, because now it could potentially extend the closing because of the timelines needed for petition work to be done. So if you're going to do a listing, by all means, reach out to us. We'd be happy to order a complimentary title report for you. The added benefit of that is once you are in escrow, when we place the official title report at that time, the title company can do it really quickly. I mean, it's already there. Also, we always tell listing agents, feel free to share that title report to any prospective buyers, because as you know, part of the purchase contract calls for the seller to order a title report and provide it to the buyer. So if you're already giving the buyer, the buyer's agent, the complimentary title report ahead of time, hopefully that will move them along in their process and they can approve due diligence, get their additional deposits in escrow quicker. So it's just a win-win, I think, if you request that early. And again, that's something that we do complimentary to the brokers. So you might be wondering how title actually prepares a title report. Where does all this information come from? It basically comes from a lot of different sources. Anything that you find on a title report is essentially public record. So the biggest part of how we gather information to present into a title report is from what's called our title plan. So Title Guaranty has a department that we call a title plan. They are basically taking all the information from all recorded documents at the Bureau of Conveyances and compiling them into a database that we have. Also, they compile basically all of the documents PDF, so we have access to those. Those were things like deeds and mortgages, tax liens, anything like that that's recorded against the physical property at the Bureau of Conveyances. We essentially have the duplicate of that. And that title plant is, I think I once did like a tour of the title plant, and they were showing on a deed, they take, I can't remember how many bits of information, and maybe Andrew can tell us later, but they take like 7 or 8 bits of information from every recorded document. You know, they're taking the grantor's name, our seller's name. They're taking the grantee's name, our buyer's name. They're taking the property tax identification number. They're taking, is this a deed? Is this a lease? They have the date of the document. They have, if there's any encumbrances or anything like that, they're pulling all this information and flowing it into our title plan. So we basically have a copy of what the Bureau of Conveyances has in public records. And we've been doing that digitally since the early 80s at Title Guaranty. So all the way back to 1980, we have basically a duplicate of what you would see online at the Bureau of Conveyances. So we can do our own internal searches. Now, there are times that we do have to go to the Bureau of Conveyances and get additional documents or old documents. So searches that predate that, you know, a lot of them are on microfilm. We have a lot of microfilms in-house from the older Bureau of Records. But sometimes we have to go even further than that. And then that's when we actually seek out the Bureau of Conveyance to provide us information to help bolster our title plant data. Another source of information that we get is from the county tax offices. So you'll note that on any title report, any title guarantee title report, if you look to the last page, you will see that there are the county real property tax information on there. And we disclose the last 2 years worth of real property taxes in the payments on there as a disclosure so that the buyer has an idea historically what the taxes have been. But also with that, it's, you know, identifying whether this property is owner occupied, and there's a lot of other information that comes from the county tax offices. We also check with the circuit courts, bankruptcy courts, and federal courts. There's documentation that could be recorded in each of those courts that could affect real property. So think of things like child supports, for example. If somebody had a child support lien against them, it's going to attach to any property that that person owns. If a federal court files a judgment, like a summary judgment against somebody as a result of a lawsuit, let's say, and they're garnishing property or they're levying a lien against it, a lien or the tax lien would populate, and then we would report that on our title report as well. There's also what's called the land court, the assistant registrar of the land court. So we'll get into a little bit more information later on about the differences between regular system and land court, but land court is a separate entity within the federal government that monitors and keeps track of recorded ownerships of property. So there's a special section that we can pull information from there. And then the last bit of information gathering comes from generally circulated publications. So publications like the newspapers are required to, you know, publish. A good example is like mechanics liens. So if a construction was done on a property and the construction's completed, the contractor has to file notice of completions. And then so we literally get the newspaper every single day. And it's not just the Star Advertiser, it's different county and regional newspapers. And they're looking through the publications because we input all that information and somebody's typing it in into our data. So we know that Auntie so-and-so may have died, and that's now public recorded information because it populated in the website. That might affect a title report that Auntie so-and-so owns, and we can properly disclose or reflect that when we generate a title report. So you might ask yourself, why is a title report important? Basically, it's there, like I said, it's a reflection of what the current condition of the property currently is. And then it's going to there to protect the seller and the buyer, because from the buyer's perspective, it's helping the buyer understand what they're purchasing. Maybe it's going to show if there's any type of restrictions on the property. Perhaps they live in an association, and if you look at the recorded association documents, you'll note that there's some restrictions on what color you can paint your house. So it's things like that that would help the buyer understand the totality of the property that they're purchasing. And then as far as the seller, it's helping to identify who actually has the right to sell, because the first page of our title report, you'll see that it's going to identify the current owners of the property. So that's important for you as a listing agent. Are you talking to the right person? You may be talking to John and come to find out he's the nephew of the actual owner, and you got to actually get the contract signed by the aunt or the uncle. It's also going to show any existing liens. So not only do we do lien checks against the current owners of the property, if the buyer is going to get some type of financing, we do lien checks against the buyers. The new lenders want to see if there's any type of outstanding liens that may affect their ability to lend. So again, I think it's important that agents look at a title report and again, order it early. You can look at these things and you can have a discussion with your title officer or your escrow officer in advance and talk about problems that you may see and things that we can do to address that. So some of the things you might want to ask, like if you're representing a buyer or does the seller, or not only the buyer, but if you are the buyer and you put yourself in their shoes, what might the buyer ask? Like, who am I actually buying this property from? Well, the title report will show you that. The title report is going to show the current owner of the property. Again, I noted, are there any limitations to the property? So a big one, in addition to like restrictions, is easement usage. So a lot of properties in Hawaii might have shared driveways, and then the underlying documents would say who's actually allowed to use that driveway, under what conditions, are there restrictions, can somebody drive across your land and access a gate that's on the backside of your property? There's all kinds of things that could be recorded against your property. So it's important when you're reviewing it with the buyer to, not just gloss over it and say, oh yeah, that's our seller, it's good. You actually want to look at the report itself. The cool thing about our reports is that the documents, if you've seen a digital report that you would receive from us, the documents that are outlined in the title report are actually hyperlinked. So they're a different color than the report. They're blue. And that's because we have this system generate, like our title plant that has a backup of everything, and then it has PDFs of everything. So we have links to basically all the documents, like I said, back to the 80s. So you could actually click on the hyperlink within your title report, pull up that document with your client. And this works even if you forward the prelim to your client. So if you forward this prelim to your client, they should be able to also click on the hyperlinks and pull it up. So you can sit with them, pull up these restrictions or any other type of underlying documents, review them together to find out exactly if there are any restrictions on those. And then if you're the seller, you may have questions, that you might ask when you get a title report. Are there any issues that you need to address? The biggest thing is changes of ownership and property. If people die, or if people get married, or your marital status changes, or you get a divorce, those things can affect how title is reflected. So it's important to, one, know whether the property is regular system or land court, because that's going to really determine what is needed to correct that. So again, working with your escrow and your title officer is pretty important in that regard. And then the second thing from a seller standpoint is you want to find out if there's any existing liens or mortgages on the property. Now, ideally, your seller should know exactly what they owe on the property by way of mortgage, but oftentimes we'll get a title report that comes back and it maybe shows an old mortgage. Maybe they did a refinance with another company years ago and it may have gotten paid off, but maybe over the course of time, that release never got recorded at the Bureau of Conveyances. So it's still showing attached to the property. And so those are things that we can address. So we can work with your client. They can maybe provide us proof of payment or some sort of canceled promissory note to show that that loan's been paid in full. So we can quote unquote clean up the title report before it actually goes out to the client. So again, another plug for the ordering a complimentary search is if you see those things on the report, we can clean them up before you're actually in escrow and before you're giving that to the buyer. So the buyer's not questioning, why is there this old mortgage from 1975 on there? Things like that. So let's take a quick dive now into the actual report itself. Today we're really going to focus on Schedule B because to me, Schedule B is where you'll find the most pertinent information to your transactions. I'll quickly just reflect on Schedule A. So Schedule A is the very first page of our report. It's going to show ownership. It's going to show who owns the property, how they vest title, and then it's going to show you whether it's leasehold or fee simple property. So that's pretty much that's on the first page. First page also will have the title officer name and contact information. It'll also have the seller, or sorry, title officer, and then the escrow, myself. But jumping into Schedule B, so Schedule B is going to be anything that's recorded against the property that would be shown as an encumbrance. So these are things that as a seller you want to address because we either have to pay them off or address them somehow. But then also as a buyer, you might be wondering how this affects you. So Schedule B will contain the following information. It's going to contain any type of encumbrances. So those are things like liens, property taxes, easements, boundary issues, and then coverage exceptions. So exceptions meaning these are things that won't be covered under the final policy to the buyer because we're basically disclosing it. These are items that we know affect the property and we're disclosing it to the buyer. So the first thing you'll see in Schedule B on all real property will be an item 1, and it'll be the real property taxes. So real property taxes, always important because they essentially hold the first lien position. So even if you have a mortgage on the property and you fail to pay your real property taxes, the tax office can foreclose on the property and sell it to the highest bidder. Now that's why you'll see a lot of the lenders require escrow accounts, not to be confused with our escrow account, but a bank escrow account to hold funds because the bank wants to make sure that they are paying the real property taxes because they don't ever want to see the real property taxes get unpaid because now it jeopardizes their mortgage position within the property. So real property taxes, always first. Escrow will make sure the taxes are current and we prorate that through the escrow settlement statement. The second thing you'll always see on a title report is mineral and water rights. So the state has basically control of the mineral and water underneath your land. And if, there's certain exceptions to that, but they'll be spelled out in a title report if that applies. But in most cases, most properties, you know, if you dig and you find some type of minerals, you can't keep those. The third example here, item number 3, this is a deed. So there's a deed that was recorded in 1946 that may have some underlying information within that, some restrictions or things on it that affect the property. So again, you can click on them if perhaps the document is not hyperlinked because this is so old. You can ask the title officer or escrow officer to pull those for you. They might have to go to the microfilm, get those scanned, and then they can PDF them out. But generally, within half a day, you can get that information. Some other examples of encumbrances that you would see on a Schedule B are things like easements. So this is a big thing that you'll see. Easements on a property, whether it's for sanitary purposes, sewer lines, utilities for access of power poles, things of that nature. This is important, especially if you're a buyer. Just as an example, my property, I have a ditch. So I'm up against a hillside and there's a ditch and a retaining wall that collects all the water from the mountain and then it funnels it under my backyard into a cistern that then dumps out under the street. So when I got my title report, I see that there's this recorded easement with the city and county, and I can pull it up and there's actually a map. So it outlines a survey map on my property. So I know that I cannot build or encroach onto that. So when we were thinking about putting a deck onto the back of my house, it limited my options of what I could do because I knew I couldn't put some pilings or something right over that easement, because if they ever needed to come and, you know, fix or tear out that drain, they needed to have access to that. So certainly that's a limitation for me as a buyer on the property. So again, important when talking with your buyers about some of these easements so you can find out it actually restricts the use of their property. Number 5 is a grant. Also, this is a grant for easement for sewer purposes, similar to number 4. There's item 6 will show any type of declarations. So sometimes there's declarations on properties when they're in associations. They might disclose that there's actually an association. I've seen declarations on properties that might just be a 2-unit CPR, and it just talks about who's, there's the shared driveway use and who's responsible if it, fails and they got to replace the road, things of that nature. Number 7, mortgage and financing statements. So these are loans that the seller took out against the property and used the property as collateral. The bank is going to secure the property by recording a mortgage. So this mortgage would be the responsibility of the escrow officer to collect for and pay off out of the seller's proceeds before we close escrow. So there will be things on a title report that from a buyer's perspective, you don't really want to see. Like, you don't want to see a mortgage on there, but you have to know that there's certain items that will stay on the property. So in this case, items 1 through 6 will stay on the property because we call it running with the land. Regardless of ownership, those things run with the land unless canceled or terminated. Other things that we don't want to run with the land are things that the seller imposed on the property. So it's seller, the loan that the seller took out. So even though it looks like it's an encumbrance, item 7 will be removed from a final policy when issued to the buyer at closing, because the title company knows that the escrow officer has collected for and paid off this mortgage, so that when the property transfers to the new buyer, let's say the buyer paid it with cash, he doesn't have any encumbrances now. There's no debt on the property. Item 8 is something relatively new. Not sure if you guys have seen this before, but I'd say probably within the last 2 years. Actually, it might be longer than that now. But we still get questions quite a bit. It says this transaction may be subject to a FinCEN geographic targeting order. So FinCEN is a federal government. I think I might have some slides that we're going to talk about this later. But it just basically is a requirement for the title company to vet who the buyer is if the buyer is buying the property with a company or an LLC. So it's the government. It's like an anti-money laundering statute, I guess, and they're trying to find out who the sources of the funds coming in on cash transactions are for the purposes of trying to stem any type of money laundering or fraud. So there are some forms that the buyer would need to complete in order to remove that item, number 8, from the title report. And the escrow officer will share those with you and go over those with you. Now, if the buyer is taking the property husband and wife, individual, that doesn't apply. So that'll automatically get removed. There's nothing else needed. If they're getting a loan from a federally insured bank, a normal bank or a lending institution, that is not required as well, because at that point, the responsibility falls on the lender to do the disclosures. So it's really for cash transactions with LLCs. And I think there's a limit. I want to say it's over 300,000. But to be honest, that's pretty much every property in Hawaii, it seems like. Oh yeah, here we go. The next question here. What is the FinCEN? So FinCEN stands for Financial Crimes Enforcement Network. It's set up by the Treasury, again, to combat, fraud within the financial systems. It's going to require, there's quite a few things that the buyer has to provide to escrow, and we have forms and they have to complete it and they have to provide photo IDs. It's a little bit cumbersome, but and oftentimes they'll complete it and we send it for review, and there's kind of some back and forth because some information might be missing. But we'll work with your clients usually directly on those. And again, so for the criteria for reporting, so that item number 8 might not show on all title reports, because if title knows that it's a commercial property, for example, the reporting doesn't apply. So they're not going to show it on there. But if it is an improved residential property, if it's over $300,000, if the buyer is buying in a corporation, if the purchase is made with cash without any type of loan from a bank, and if they're paying with cashier's checks or certified funds or wire, which that's the only way we would accept final payment anyway. And if the property is located in any county within the state of Hawaii, which those are the only transactions we do, if those criteria are met, then we have to report. So that's something your escrow officer would work for you on that. So when working with buyers, just be prepared for them for that if you're dealing with clients who intend to take title in an LLC. So some of the things that you might need to share and get from your buyer are they have to provide some type of corporate authority documents. So we need to know how the structure of the LLC is, or the corporation, I guess. Find out who they are. They have to disclose anybody that has a 25% or more interest in that LLC. Those people have to then provide their IDs and scan those, and that becomes part of the package that we report to the Treasury. So it's basically disclosing anybody that has a beneficial interest over 25%. And then usually a corporate officer of the company signs the actual form saying, yes, these are the, maybe it's only two people. These are the two people that each own 50% of this company. So some other things to think about are, how do the liens, one, how do they show up on the title report, and how do they affect the property that we own? So there's two types of liens that you want to think about. And one is a voluntary lien and one's an involuntary lien. So voluntary liens are things that are created by somebody knowingly. So if you're taking out a mortgage, for example, your bank is going to want to record a lien against your property. That was voluntary. There's things like involuntary liens that the seller may not want on the property, but it's going to show as an encumbrance on our title report that we're going to have to address. So these are things like child support payments, tax liens. If there was a lawsuit and there's any type of settlement and judgment perhaps that's filed and recorded where they're trying to recoup funds via the sale. So they record an involuntary lien so that it attaches to the property. Because once it attaches to the property, it's incumbent upon the escrow and title officer to make sure that we properly collect for those, satisfy those liens. Because if we don't and we transfer the property to the new buyer, we don't want those liens, because those liens are going to still attach to the property. We don't want them to go after the new buyer because we already guaranteed them that they owned it free and clear. So that's why the title and escrow work hand in hand to address these voluntary and involuntary liens. So some of the involuntary liens are things like the child support, and this is what it would look like if you saw it on the title report. It's going to show stipulated judgment for paternity. It's going to say it's for the Child Support Enforcement Agency, when it went into effect. And the important thing to note about these is they do not expire. So they will continue to show on the report. The escrow officer will send a demand to the Child Support Enforcement Agency to see if they are current. If they're not, they're delinquent, we would collect and pay them current because the way the state sees it, they're selling an asset and getting proceeds that should go back to the child support. Another thing you'll see is federal tax liens. So these, again, filed by the IRS. They expire in 10 years. They have the option to seize the property. So they're recording a lien. And then if you don't pay within a certain amount of time, I guess essentially they could seize the property through a tax foreclosure type sale, in which case the government would take all the proceeds first. And then, if there's anything left over, give it back to the client. We also have state tax liens to think about. So this will show up as state of Hawaii, Department of Taxation. Can come from various types of departments within the Department of Transaction. It could be things like payroll taxes or state income taxes that were not paid, or there's delinquencies on. Those don't expire. Also, you'll see some judgments. Depending on when or what type of court they're filed in, they have different expirations. So district court is 6 years from the date of filing. A circuit court is 10 years. And then if it's a federal court judgment, it could be 10 to 20 years from the date of the filing. So that's why these are things that we would consider run with the land, and then with the usually it's against a person. So in this case, like the plaintiff, but if they own the real estate, then that's how it gets attached to the property, because the state or the federal government knows that they have some assets and they want to encumber those essentially and try and get their hands on it should this person sell that asset. So you might ask yourself, okay, I've going into a listing, I've ordered a complimentary title report from Jeremy and titled early, I've reviewed it. It looked like a lien popped up against John Lee, our seller. You don't know if it's the same John Lee. You go have your meeting with your client and your client says, hey, what's this tax lien against John Lee? That's not me. So there's a few things that escrow can work with you to actually remove those from title. Again, this is why it's important. I think if you get one early, you can clean up some of these issues. So it's not to scare the buyers. So you can give them the cleanest possible report possible. We might ask for the seller's social security number. Depending on the lien or judgment, some of the old liens, like I want to say like 90s or before, actually have, even though it's public record, have people's social security numbers on there. I mean, that's just how they did it back then. So if it has listed the defendant's social security number and our client tells us what their social security number is, we can just say, oh, it's not the same. I'll email Andrew, our title officer, and he says, yep, okay, I'll remove it, and then just remove it from the title report. Sometimes we can't validate, we don't know, because the tax lien itself doesn't have any information that would validate it, like it doesn't have an ID number. So we can send a form to the client that basically is authorization that we contact the tax office on their behalf. We'll send a demand to the tax office and ask them, hey, can you verify that this is not the same person? And we provide our client social security number. So that way the tax office then takes our client social security number, compares it to what they have in their records. And if they say, yeah, it's not the same, we'll get a report back that says it's not the same. I share that with the title officer and they'll update the report to completely remove it. Sometimes we're even more clever than that. Like I've seen cases where the lien was from like 1980 and my seller says, well, that possibly can't be me because I was born in 1990. And title's like, yep, okay, yeah, we see that this guy's definitely can't be that guy. So they'll remove it. And then jumping on to the last thing that we wanted to talk about today, which is understanding the differences of Hawaii land systems. So in Hawaii, we have two systems of recordation. There's the regular system and the land court. You may have heard these, you may have heard about it, but you might not actually know what it means or how it affects you. So what I'll talk about a little bit today is how it might affect you and things you just need to think about when dealing with the buyer or seller if the property is in one of these systems. Because depending on the system, the way you address something is kind of night and day, to be honest with you. So what's the difference between these two systems? So regular system is just public recorded documents. It's very easy to record documents because the state doesn't confirm whether it's valid or not. So in regular system, this is where you'll find what we call rogue deeds, where you'll get some people just recording all kinds of kind of like garbage documents saying, I own this property and I gifted it to my son. But we have the chain of ownership. So we know that that deed, even though it's recorded because the regular system took it and this person said they own this property and they conveyed it to their daughter or whatever, the title company says, well, we don't acknowledge it because we know the actual chain of ownership. Again, the regular system is just accepting whatever anybody gives them. So if somebody gives you a deed, as long as they have the fee to pay the recording and it doesn't go afoul of any of the recording requirements, they'll record that document. So I guess the pros, it's easy to record things. The cons, it's, you might find junk on the property that isn't really pertinent to your transaction. Now, land court, on the other hand, is kind of the opposite. So this is the stricter system of recordation where land court actually validates the document. So if you sell the property to somebody else, they're looking at the document prior to that to make sure you are the actual owner of the property before they say, yes, okay, now we accept this document and we accept the transfer of ownership. They have what's called a transfer certificate of title, or also known as a TCT. This is like a recordation of, again, who's the legal owner of record. So they know now any deed out needs to reflect this owner on property. The confirmation of ownership by the state is a longer process. Right now, I've seen deeds come back from the Bureau. So we've submitted them for recordation, and it's already recorded. It's in public records, but land court doesn't get finished processing and sending them back to us 5 or 6 years later. So I'm getting deeds in the mail that I send out to the clients for transactions we closed 5, 6 years ago, which is kind of ridiculous if you think about it, but that's how backed up they are, I guess. And then the owner of the property is responsible for maintenance of the TCT, and they must file a petition for any change. So this is important because this is where we're going to talk about petition. So the joke is, if you have a land court property, just don't die, don't get married, don't get divorced, because it messes things up and you got to file a petition, and petitions cost money, they cost time, they can extend closings. At the end, I'll give you a little anecdote about a file I'm working on right now that we're trying to do a petition, and just yesterday they rejected our petition for the 3rd time. So a lot of back and forth. And then you have the double system, which is essentially recording it in both systems. So not only is it double fees, but you have to comply with the recording requirements of each system. So there's some rare properties in Hawaii that fall under this double system, which is pretty unusual. So again, petition. So the joke, don't get married or change any way you hold title, because if you do, you're supposed to do it at the time. So let's say you got married, and you should file a petition, but most homeowners don't know that they need to do that. And then they don't find out about it until they go to sell their property and realize they're still listed on the record as 2 single individuals who maybe bought the property when they're dating. And now they're trying to sell it, but they're actually a married couple. So they have to petition land court to note the marriage, note them combining, maybe note the one spouse changing the name to match the other spouse. So there's a lot of things that your seller might not instinctively know to do when they have these life events where people die, or what people, if it's in trust and they change a trustee, anytime that those things happen that affect title, they're supposed to change and petition land court. So again, if you know it's a land court property, I'd say reach out to title and escrow, get a title report, because if there's something that needs to be done, those are things that you can do while you're showing the properties, before you're under contract. Hopefully that they get cleared up before you're in contract, but even if not, at least you got the process started, saving you some time when you're in escrow, when you have an anxious buyer who just wants to close. My instance right now, our transaction is now, I think, about a month and a half delayed, because each time they submit a petition to land court, it's about 2 to 3 weeks for them to review it. And then, so the first time they said, oh, there's some issues, we need more information. So the attorney amended it and added more information. We resubmit it. Well, instead of kind of jumping to the front of the line, they put you in the back of the line, and then you got to wait another 2 weeks. And so now we've gotten 3 rejections. We're going on our 4th. I just hope that this thing closes. And, for the seller's sake, I hope the buyer doesn't get impatient and walk away and maybe find another property in this time that maybe better suits their needs. So a lot of bad things can happen, with a delay in an escrow because of a petition. So if you're talking with your client and you represent them, these are some questions you might want to ask your sellers. Has there been any marriage? Has there been a divorce? Another one is, did people change their name? Even not through marriage, like people change their name. And also death. The death is probably the biggest one and kind of the hardest one to fix, because depending on how they hold title, does it mean it needs to go to a probate? Was a probate actually open? So these are conversations you should have with your seller when you're listing a property. I mean, I've seen numerous times where somebody's talking to somebody who they think is the point of contact for the property because it's the son, but then we do a search and legally the property is still recognized as the parents who maybe died 10 years ago, but nobody did any petition, nobody did anything. And now we have to unravel this puzzle to figure out how the property actually gets transferred into the son's name so that the son can legally sell the property, so that the son could actually legally enter into a purchase contract or even a listing agreement with you if they're not officially the legal owner of record. So those are some important questions I think that you would want to have when you speak to your seller. I know I covered a lot today, and I think that's it for my slides. Yep. So I would like to actually bring Andrew back on
Yeah, Jeremy,
if
thank
there's
you.
any questions that anybody else has, and I will stop
Yep. We do have
sharing.
some, yeah, we
I
do have a
guess,
couple questions, and thank you so much. And I'm always blown away by what you guys really do behind the scenes. All we know is, hey, where's my deal? Where's my title report? But really what it takes and what you guys have to go through is pretty amazing. So, quick questions. One is, how do you verify the loan amount payoffs? How does that happen? Do you have to contact the
oh,
lenders?
yeah. So that's a responsibility of the escrow. So yes, sometimes you'll have a seller that says, "Oh, I have the payoff demand here. Like, let me just give it to you." For like, I guess, audit purposes, we cannot accept a demand that came directly from the borrower. Escrow will have to formally send a request to the payoff lender, and then the payoff lender sends a request back to us. Most payoff lenders nowadays require some sort of authorization. So that's why it's important to have your sellers complete and return the opening packets that get sent to them, because one of the paperworks in the seller's opening packet is like a loan payoff authorization form. So that way we have something in writing from them that says, to all lenders or debtors, I'm giving authorization for you to release information to Title Guaranty because we are selling our property. With that authorization, I send that and it's all usually email these days. We get a payoff, and then again, right before closing, we'll do an update on that, because throughout that month or 2 months, depending on your term of escrow, they may have paid down that loan a little bit more, and we'll update that right before closing.
Okay, Andrew, anything you want to add to that?
No, I think Jeremy covered it.
Okay.
It
All
is
right.
an escrow function to obtain the actual payoff amount
Yeah,
directly from the bank.
and you know how the title report will show the existing mortgage on there? When we're ready to record, I'll send what's called a title update to Andrew, and I'll say, "Hey, we're ready to record this transaction. Here's our new buyer." I have to let Andrew know that the mortgage, let's say it's mortgage number 7 on the title report, I let Andrew know I'm going to be paying that off through escrow. So he knows that when we close, when he issues a policy to the buyer, it's not going to make any reference to that mortgage. Um, and if I tell Andrew we're not recording that or paying that off, that's going to throw a red flag to Andrew. Andrew's going to be like, "Wait, why aren't you paying that off? Because you should pay it off. There's a lien or there's something attached to the property, because if you don't pay it off, that could potentially come back and hurt the buyer." So we kind of work with each other on that, but he's my checks and balances if
Okay.
I
And
don't
then
address a mortgage.
the one that we have with you right now, kind of a interesting, timely one. This one requires a historical search,
Mm,
which actually is a cost, a
yeah,
pretty expensive cost. Can you explain a little bit what
sure.
that is and how that comes about?
Yeah, so like I said, we can generally provide you a complimentary title research search. Um, our title searches are usually based on the last time we searched something. So if we searched and insured a property, let's say in 2010, we know we did all the back work to get up to 2010. And now going forward, we're going to close in 2024. We're really only kind of searching anything in the last 14 years that may have changed ownership or any mortgages. Occasionally, we'll come across a property where we haven't searched it, meaning it may be within a family's chain of ownership for 100 years, back to the early 1900s or even earlier than that, where nobody searched it. So in order to provide a title search on that, it requires special people to do that. A lot of the old documents could be in Hawaiian. We have Hawaiian people on staff that can read and translate deeds in the public records back from then. They're almost like genealogists. They have to figure out genealogy because a lot of the times back then, people died and they just said, yep, oh, it goes to my son, but it wasn't officially done that way. So we have to identify all the potential heirs that could benefit and be a part owner. It's not uncommon to get a title report with 20, 50, even more owners listed in Schedule A with the smallest percentages you'll ever see, like to the 6th decimal place. And then those are specific types of transactions. So if you probably wouldn't ever come across these because there's special attorneys in town and it's called quiet title. They're helping clean up these old properties that are owned by generational families that have multiple people on title. So I think ours is like $750 or $1,000, something like that. I've seen title reports cost $20,000 and take 2 years to complete because they got to go back so far and they got to get all these
Andrew is
things
shaking
cleared
his
in.
head. So Andrew, is this your department that actually goes and opens up these books, crack the old Hawaiian books
Uh,
out?
no, we have a separate department. It's called our Historic Title Services Department. Um, in the residential department, we're generally working with properties that don't require historical searches. The historic searchers, are generally working at a different pace. They're reading documents that are quite old, documents that aren't scanned. They are paper documents. Totally different department. Um, but we do get the opportunity to work with them depending on the property. If the property requires a historic search, then generally the historic title examiner will do all the work and generate the title report, at which point the completed report is handed off to myself.
Very interesting. I picture them with a quill pen, writing the thing down. Hey,
Yeah.
so guys, what's the difference between a preliminary title report and then the final title report?
You want
Anyone?
to take that? You want to take that, Andrew? Like a
Yeah, sure.
final policy, I guess. Yeah,
Yeah,
probably.
so the preliminary report is a report that's done preliminary to issuance of the final policy. Uh, the reason why we give the preliminary report is so that the buyer knows what their policy will look like after closing. Um, so uh, it is very similar. And as Jeremy mentioned earlier, those items that quote unquote run with the land, they will stay on the report. Those voluntary and involuntary liens will generally be removed as a part of the escrow process. But the report itself is kind of like a preview. It's preliminary to your policy and is basically a snapshot of what your policy will look like.
Okay. All right. And then this question kind of goes to something you touched on earlier and kind of when it starts to get complicated down the chain. So in this particular case, the agent, the client just passed away, and the property is now going to go to the wife via a trust. And now the wife is going to want to come in to sell the property. And oftentimes we get the clients who say, "Oh, my parents passed away. They gave the property to me." But when we look at the title work, there's nothing there. Do you see that often? And what needs to happen when someone passes away and the property is supposed to move to the next person?
I can take this one. So if the property is held in trust, then generally, uh, the person that created the trust um, is the initial trustee and controls the property. The property is titled in the trust. If the original trustee or what's called the settlor or the grantor of the trust, the creator of the trust, once they die, the trust itself will contain information as to what to do with the trust property upon the death of the original creator of the trust. And the trust will govern. So, generally trusts are not recorded documents. They are generally private documents. So if title is held in trust and there has been a death, generally for title insurance purposes, we require a copy of that trust. We read the trust to determine if there are any specific provisions within that trust that have to do with that property.
So Andrew,
If
if someone passed away, it's in a trust, it's going to go to the benefactor or beneficiary. Um, is that a good time for them to just come, even if they're not going to sell, should they come to escrow, open up an escrow and have that recorded, that transfer?
well, I've seen it done any number of ways. You know, when the original trustee is deceased, the trust says, okay, well, once the original trustee dies or is no longer able to serve in some other way, then a successor trustee is appointed. So if property is held in trust, then the owner of the property would be the successor trustee of that trust.
Hmm.
Now, sometimes the successor trustee will come in and convey the property to those persons that were listed as the beneficiaries of the property. And so you would see the successor trustee come in on a deed to convey the property to the beneficiaries. And then the title report can be updated to show that
Okay.
change in ownership. So it's no
Okay.
longer in trust.
So if we
Other
know
times the
someone,
property is sold.
if we know
Oh, sorry.
someone and that happens, maybe it's good advice to, hey, might as well have it done now. Just get it taken care of so that the property transfers.
Can be done. You know,
Okay.
it's completely up to the successor trustee.
Okay.
Oftentimes, I'll see the successor trustee will sell the property,
Right.
and rather than conveying the property itself to the beneficiaries, they would um,
Take
convey
the
over the
proceeds.
proceeds
Yeah.
Right.
of the
Okay.
sale.
Okay. And
But it
then
also depends on
yeah,
if it's regular or land court, right? I mean,
yes.
because then you're talking about petitions on the appointment of a successor trustee, as
L-
opposed to just having title acknowledge a new successor trustee. Is that correct, Andrew?
Okay. Yeah.
Yeah,
And
so
mhm.
if it is a land court property, a petition is required because the TCT, the transfer certificate of title that is maintained by land court, is still showing the original trustee. So if you come in with a deed with the successor trustee's name on it, land court will say what gives. Actually, the owner is the original. We have to let them know, oh, I'm sorry, the original trustee is deceased. Here's a petition from that successor trustee presenting evidence, the death certificate of the original trustee, the trust document itself, to prove that they are now
Okay. I
the
gotcha.
owner.
Okay. Two questions about land court and regular system. Number one, how do we tell which is which, or can we tell based on the prelim? And can you transfer something out of land court into regular system?
You can tell the land system generally by looking at Schedule C of our title report. Schedule C is the legal description of the property. Only certain properties in Hawaii have been registered with the land court. All the rest of them are regular system. If you review Schedule C, and if you see that the legal description of the land is Lot 1 of land court application 100. Uh, that indicates that it is a land courted property. In order to determine your land system, the place you're going to find that is in Schedule C. If you're not sure of your land system, feel free to contact Jeremy or I, and we can look over the prelim with you to determine if it is regular system, land court, or double. And
Okay.
then as far as transferring out of land court, there is a process. It's not too common to actually remove a property from the land court system and bring it back to regular system. Generally, this is not done for, um, you know, regular residential properties.
Okay.
Uh,
Yeah, the only time I've seen it is when a developer might buy a whole parcel of land that they plan to turn into a condo or subdivide,
I see.
and they want to deregister it so that it's easier for
Okay.
them to do that going forward. But because
And
it's expensive and it costs takes a lot of time to do it.
And in the modern era, I know Title Guarantee, you're handling a lot of the Ward Village projects. Are those generally regular system?
I don't know about those particularly.
Okay. I got to stump you guys on one question.
Well, the the land courted properties, there tend to be quite a lot of land courted properties in Honolulu proper.
Okay. Okay. And then
Yeah.
one last question, and we'll try to keep this one brief. I know it could be a long answer. Um, why do some companies not want to include the parking stall numbers on the prelim and not on the final?
Uh, well, parking stalls can be quite tricky. Um, uh, the reason why title insurers will generally be hesitant to include parking stall information is due to the fact that oftentimes um, stalls will be swapped between condo unit owners without actually memorializing that swap with a recorded document at the Bureau of Conveyances. And if it's not recorded at the Bureau of Conveyances, then it's not public record and there's no way for us to know that it actually happened. Um, Another reason is, uh, people will change the actual stall numbers in the garage, like maybe they repaint the place and new numbers are placed on all the stalls, at which point you think you have stalls, stall numbers 1 and 2, but when the condo was first created and in the recorded condominium documents, those stalls actually had different numbers.
Right. Or they're now A and B or whatever they might be. And then
Right.
the other one, and know, Jeremy, we dealt with this, the declarations were not amended. So, escrows were open, stalls were closed, but they never amended the decks. Well, hey guys, thank you very, very much, Peter, Andrew, Jeremy, for today. It's fascinating. It's great to see. It's great to hear. I know it's a good value to all the agents. So we thank you very, very much for doing this and all that you do it throughout the year. So to everybody else, and until next time, happy selling, be well, be kind, and aloha. See you guys.
See you, Patrick.
Bye. Hi, I'm Patrick ONeill with Luxury Homes International. Don't miss next week's webinar with economist Paul Brubaker. Be sure to hit the subscribe button below and give us a thumbs up. Thank you.